Hello everyone and welcome back to the channel The Commerce Coach. So today we are back again with another video and the video lesson that will be talking about section number 151 of certainly the Companies Act 2013. And yes, today we shall be seeing small shareholders director, or basically section number 151 talks about appointment of small shareholder director, section number 151. So today we will be covering section number 151. Very small section but have a good relevance when we talk about the examination part, and yes, of course, we shall see each and everything under this particular section. So let's get started. Now, first of all, section number 151. You can get these notes by clicking on the link given in the description box. Okay, so in the description you will find out a link. By clicking onto such link, you will get these notes. These are the handwritten notes by me and presented by the Commerce Coach. So section number 151, it talks about appointment of director elected by small shareholders. The full name is appointment of, what did I say just now? Appointment of director elected by small shareholders. Now see, we are talking about a director who is appointed by small shareholders, a director who is elected by or selected by small shareholders. So first of all, we shall see where does this section apply, or what is the applicability of this section. Okay, first of all, we shall see where does this section applies. So basically, this section applies, or this section says that a listed company may have one small shareholder director. Okay, so this talks about a basically listed company. So it talks about listed company only. Okay, so a listed company may have, see, it is not the requirement of the law, it is not the compulsory thing to have, but it is optional as a part of the company to whether opt to have this particular director or not. It depends upon the company itself. Now, a listed company, each and every company that is listed comes or falls under the section of 151. Now this may have one. Okay, so what is the number of small shareholder director that a company which is obviously willing to have a small shareholder director can have? The number is 1. This can be a question as per the MCQ framework. Okay, now see, we have seen where does this section apply. This section applies to all the listed companies which may have, means they have the basically option to have or not to have a director elected by small shareholders. Now we shall see that what do we mean by small shareholders. Okay, so because this word is coming again and again, see, we shall see what do we mean by small shareholders. Is it defined in the law? Yes, it is defined in the law that what do you mean by small shareholders. See, two ways are there for this, first way and the second way. Okay, or let me make it more clear to you guys so that you can understand it well. Let me make a proper flowchart. Okay, now For this we have first of all here and then here. Okay, now the first option and the second option. See, there are two meanings of this word, small shareholders. First meaning, by company itself, by company. Second meaning, by law. Means the law also has defined something about this particular term, and by company also they can define their own terms. Okay, see, by law, what has been defined by law? See, law has defined something about small shareholder directors. See, it means the it means the shareholders. It means the shareholders who holds shares not more than, means they can hold equal to, or they can hold equal to or less than of 20,000 value. 20,000 value, which value? Nominal value of shares. So these are the small shareholders basically as per the law, who holds equal to or less than 20,000 nominal value of shares, or basically who has or which has 20,000 shareholding in the company. Now by company they can define any such amount. They can also define any amount which will specify basically the meaning of small shareholders. As per the law it is 20,000 nominal value, but as per the company it may define that 25,000 nominal value. That's for example only, for example purpose only. Okay, so in the law you can read out that there are two ways by which we can understand the meaning of small shareholders. First of all, it can be the limit defined by the company. So basically it's all about limit. Okay, so limit can be defined by company itself or by law itself. By law it is 20,000 and by company it can be anything. Now we shall move on. See, now we are on next page. Now what do we have to study more in this? How the director shall get appointed. That's a question that might be arising in your mind. See, what do we have seen till now? We have seen that what the section number 151 says, and we have also seen that where does it apply? It applies to listed company. And what is the number of small shareholder director that a listed company have is 1. And what is the limit? 20,000 as per law, but as per the company it can define any other limit as well. Now how the director shall get appointed, or basically we can call it manner of appointment. Okay, what is the manner of appointment? For manner of appointment we can see that a listed company, see, I am talking about a listed company. We know that this section applies to only a listed company. A listed company may appoint a small shareholder directors by following either of the ways. See, first of all, which way do we have? First way here and the second way here. First way we have by suo motu. Second thing we have on application by small shareholders. Okay, so the first way is suo motu. Suo motu means the company itself. The company itself can also define the manner. See, earlier it can also define the limit for the small shareholder directors. It has the option. Now also it has the option, suo motu option, that in its own way. It means in its own way. It can define that how will he appoint, or how will be the manner of appointment for small shareholder directors. The second way that we have is on application by shareholder. Either, see, this is either of the ways. Either the company can appoint the director by suo motu procedures, or it can go with the on application by small shareholders. Okay, see, on application by small shareholders. See, for this option we must see application number basically. See, on application by small shareholder means that a particular or certain number of basically shareholders must apply to the company that yes, we must have a small shareholder director. A certain number of shareholder must tell the company basically. See, shareholder will tell the company, and the number of these shareholders will be certain. Then the company will appoint the small shareholder director. Now we shall study that what is the number, or what is the basically minimum requirement, what is the number of application that has to be submitted to the company so that it can appoint the small shareholder director. Now for this I will take you to the next page. See, we will come to here. Now see, minimum requirement. What is the minimum requirement of applications? See, minimum requirement of application is 1000 shareholders. 1000 small shareholders. Let me use the correct word. Small shareholders. Okay. Or 1/10 of total small shareholders. Whichever is less. See, now minimum requirement of applications, or basically it is notice made by. Application, you can call it application or a notice made by either 1000 small shareholders or 1/10 of small shareholder, whichever is less. For an example to make you understand, suppose a company has small shareholders. How do we get small shareholders? All those person who holds share of value 20,000 or less, but not more than 20,000 as per the law I am going. Okay, not the company option. See, a company has small shareholders as, let's suppose it as 1200 shareholders are there who are small shareholders. Okay, now by applying the provisions of section number 151, the question being asked to us is that what is the minimum requirement of notice, or what is the minimum requirement of applications that must be given by the shareholders to the company so that they can appoint a small shareholder director. The answer, the solution will be, see, 1000 or 10% of this 1/10 of total small shareholders, whichever is less, means 120. Means out of these 1200 small shareholders, the notice is required to be given by only 120. Suppose in this case, in this question, it was also given that out of 1200, 100 are ready to appoint a small shareholder director. Can they do so? The solution is no, because they required at least 120 small holders to appoint such director. Then the solution will be they would not be able to appoint small shareholder directors as per section 151. I hope you got the point. Okay, so this was the minimum requirement. See, suo motu is super easy. Company goes with its own way. But when it comes to an application by small shareholders, then we will see the applications or the notice, the minimum number of notice that must be furnished to the company so that it can appoint small shareholder director. Now, we have to see whichever is less option here, 1000 or 1/10 of total small shareholders. See, 1/10 means total small shareholder. First of all, we have to find by applying this limit. If the company has not defined its own limit, if company has defined its own limit, then we will be going with such limit. Then we shall see that whatever is less between these two options, we will select the minimum requirement that the minimum requirement must be made to the company in such numbers so that they can appoint small shareholder director. Okay, now it comes to notice, right? I told you that the small shareholder, suppose they have 120. Okay, they successfully have 120 as their small shareholder who are ready to appoint small shareholder director. Now they have to give a notice to company. Now it might be a question in your mind that what would be the duration? What will be the duration of notice? Because for everything we have a time limit, we have a time frame in the law. Okay, so can they give notice after 6 months, or what is the time limit under which they can give the notice to the company after achieving the minimum requirement? Okay, now they have to give small, I am writing the provision, small shareholders intending to propose a person as small shareholder director shall give a notice to company at least 14 days, before the meeting, and such notice must be in writing. Okay, so the time limit is 14 days before the meeting, because in meeting only we decide the appointment, basically who will be appointed as director, whether of, see, whatever type of director is there, we will appoint the directors in general meeting or in annual general meeting. So before meeting, the small shareholder, if they have decided by majority, means if they are compliant with the provisions, whether by the company's provision, that by the suo motu, or by the law provision, that means 1/10 or 1000, whichever is lower, then they shall give the notice to the company before 14 days, basically not within, before 14 days, at least 14 days before the meeting, as you can see here, before. So this is the point here, before 14 days of meeting. Okay, see, this is the provision that has been given under the law for giving notice to the company. Okay, now what will be the content of notice? See, they will give the notice. Small shareholders gathered. Okay, so they gathered 1/10 of total small shareholders, and they agreed to have a small shareholder director. Okay, now they will give a notice in writing to the company. This is notice. to company. Now what will be the content of this notice? What will they write into this particular notice? Okay, now we will see the content of the notice. What will be the content of the notice? See, the notice basically, what do you think? The notice must have, name, address, shares held, to verify that yes, they are small shareholders. Okay, or in case they have any share number or basically folio number, if any. Okay, so they must include, or they must contain, the notice must contain name, address, shares held, and share folio number basically of what. These are the requirement that must be basically written onto the notice. But these details will be of the person proposed to be appointed. See, they have decided that Mr. X would be appointed as small shareholder director. Now the details of Mr. X will be given to the company: his name, Mr. X, his address, the shares that he holds in the company, and basically the folio numbers, if any. Okay, first of all, they will mention these details of the person who is going to be the director. Now the second person, the person proposing such appointment, or basically we can say small shareholders. The shareholder proposing his appointment as small shareholder director. Now a question might arise in your mind: sir, you said that in the notice they must write the name, address, share held, and share number of the person proposed to be appointed, means small shareholder director who wants to be a small shareholder director. The name, address, share held, and share number must be written onto the notice given by small shareholders to the company. Now the question might arise in your mind that if Mr. X want to become a director in, let's say, ABC Limited, is it mandatory for Mr. X to hold shares in the company, or is it mandatory for Mr. X to be a small shareholder first in the company, then only he will be able to become a small shareholder director? For these two questions, I have a straightforward answer for you. The appointed person or the proposed person, like Mr. X, is not required to have any shares in the company. Okay, it is not required. Sir, why it is not required? Because in earlier provision we have seen, in the independent director part, we seen that voting power must not be more than 2%. Did you remember, or are you aware of this point? If yes, yes. See, if I say that he must be a small shareholder, then small shareholder can be a person who holds more than 2%. Then this will contravene the provisions of independent director. Okay, that is why he shall, or he is not required to hold any shares in the company. Simply, if he does not hold any shares in the company, then do not write these information, only write his name and address, and done, game over. Okay, now let's move on. See, every director has something called declaration. In the case of independent director also you learned some declaration given by independent director. Now declaration is very common. Declaration by small shareholder director. Every director has to declare something. See, this is the common. Basically he has to provide his DIN. He has to give basically what do we say, he has to give in writing that he is not disqualified. He is not disqualified to be appointed as director, and also his consent. So these three things would be required to be declared by small shareholder director. Now, what will be the tenor? What will be the tenor, or we can say term of small shareholder director? What would be the term? For this, let me explain you what will be the term of small shareholder director in the company. As we know the general rule, the term shall not exceed. It can be equal to or less than 3 years. Equal to or less than 3 years. 3 consecutive years. Okay, 3 consecutive years. Now, will he be able or will he be eligible to be reappointed? No, not eligible to be appointed as or to be reappointed. Okay, he would not be eligible to be reappointed. Okay, this question also done. Sir, what is the cooling period for him? Cooling period is 3 years. Cooling period is 3 years. And as you know the general rule, in these 3 years he must not be whether directly or indirectly appointed or associated with the company in any of the capacities, whether as a director, whether as an employee, whether as an investor, whether as a partner. Okay, he cannot be basically employed in the company whether directly or indirectly. Now, sir, what are the disqualification for him? Disqualification under section 164. See, if he is disqualified under section 164, then he would not be appointed or he would not be eligible to be appointed as small shareholder director. Now, vacation of office. 164 we have already done, that is why I am not explaining it again. That is a quite long section, vacation of office. This is very important because what do we call it? Vacation of office means what is the requirement that he has to vacate his office. He has to vacate his office in basically three cases. He is disqualified under section 164, as we have seen here. He is disqualified if as per section 167 he has done something, or as per section 149 he is independent director. Oh, sorry, he ceases to be independent director. Ceases to be independent director. So in these 3 points he has to vacate the office. Now, sir, if he has disqualified in under section 164, then he would not be able to be appointed as small shareholder director. We will talk about small shareholder director only, nothing else. Now, section number 167 if he has done something into section number 167, then also he would not be able to be appointed as small shareholder director. And if he ceases to be independent, basically under section 149, he is not independent director, he is not independent under section 149, then he would also not be able to be appointed as small shareholder director. Now, what is the maximum companies in which he can be appointed as small shareholder director? He cannot hold such position in more than 2 companies, basically. So you can say he cannot hold more than 2 companies. In more than 2 companies, he cannot be a small shareholder director. Equal to 2 or less than 2 companies. Okay. Now, in these 2 companies, let me explain you another thing. These two companies must not be in basically you can say conflict. If these 2 companies are in conflict, then he cannot be appointed as small shareholder director in both of the companies. The 2 companies must be independent and non-connected in any way. Then only he would be appointed as small shareholder director into such company. Now, done for today, sir, and I would thank you for watching this lesson. Hope you understood everything that I wanted to tell you. See, this is very a small section 151. Then also it is very important for exam. Especially, let me tell you, see, this is asked into CMA Inter. You can check out the past year papers. There was a question about small shareholder director. See, if any question arises in an exam of small shareholder director, then you have to write the provisions of section number 151. It can be asked into CMA final. It can be asked into CA final because directors are not there into CA Inter. It can be asked into CS. In CS also it can be asked. In CS it will be asked in depth. So for CS student especially, I am telling you that it is very important for you, and for CMA also it is very important for Inter basically. For final we have other things to study as well. That is why it is less important as comparative study is done. Okay, for now, thank you, and for next lessons stay tuned with our channel The Commerce Coach, and do not forget to subscribe the channel. And again, there is a link in the description. Please check out to purchase the notes. Okay, the notes that I used in this lesson, these notes for section number 151, you can get these notes. Okay, these are all my handwritten notes, and this will make you more good at the law. Okay, at very least cost it is available. I recommend you to check once, then you will obviously get the notes. Bye bye, take care and stay blessed.